for the second day Tax Conclave 2025. We heartily welcome you, and we are grateful that you have accepted our invitation and you're gracing the conclave with your presence in spite of your busy schedule. So thank you so much for the honor. I request Advocate Hiren Vakil Sir, Co-Chairman Conference and Vice President ITBA CA Maulik Patel Sir to escort Tushar Hemani Sir onto the dais along with the other esteemed dignitaries CA Raghav Thakkar Sashi Sir, CA Suvrut Shah Sir, Advocate Anil Timbadia Sir. All about Senior Advocate Tushar Hemani Sir. Before I begin introducing about Sir, I would like everybody to give him a big round of applause because Sir has been a speaker for all the conclaves that we have had till now. This is the 6th in the row. He is definitely the cream of the crop in his field, and we are blessed to have him this year too with us. So we are really honored to have you amongst us. Sir is one of the youngest at the bar to have been conferred senior designation by the Gujarat High Court in 2019. He is so the President of Income Tax Appellate Tribunal Bar Association, Ahmedabad, for the term 2015 to 2017. Sir has been a regular speaker at various conferences, seminars and meetings of varied professional bodies on diverse issues in the field of taxation and corporate laws. A regular writer of columns, articles and papers for professional journals and conferences, visiting faculty at various institutes, universities, college management and law school on the subject of taxation and corporate laws. Sir has these and many more achievements to his credit. Today, Sir is going to present us on the topic the role of the constitutional courts in protecting the rights of taxpayers under the Income Tax Act 1961. I extend a formal welcome to Sir Advocate Tushar Hemani, and I request CA Maulik Patel Sir to welcome him with a book. Let us all give him a big round of applause, ladies and gentlemen. I now request Advocate Hiren Vakil Sir to come forward and welcome Senior Advocate Tushar Hemani Sir with a memento. Let us give them a big round of applause. Sir, I humbly request you to come forward and enlighten us. I welcome you, sir. Let us please welcome him with a big round of applause.
Good morning, friends. A special thanks to MOC for nice words about me. In fact, I have been coming here since the inception of this conclave. And every time I come here, what I observe is that the enthusiasm of the participants and the office bearers is not at all going down. Every year, it's going up and up. such a beautiful way of coming together from all the parts of Gujarat and spending 2 days here, not worrying about the work, any other tension, just concentrate on the studies, try to update yourself. It's like new version, getting installed in everyone. It's like software upgradation. And in today's time, believe me, this is badly required. So in fact, I appreciate the efforts by all the office bearers in organizing such a beautiful conclave. And the subjects are also of wide interest. So it's like a huge buffet spread where someone will find at least one or two items of their liking. Friends, today's topic, in a way, it is not an academic topic. We would not be discussing the constitution of the High Court or the functioning of the High Court or Supreme Court, or for that matter, even the provisions of the Constitution. The whole idea is that while we all practice tax laws, and every now and then a situation comes in our way whereby we are either disappointed with the inaction of the income tax department, or we are shocked with the action or inaction of the department, or we personally believe that something is not done as per the law, as per the rules. And at that time, instead of feeling helpless, if we know that this is the situation where we can invoke the extraordinary jurisdiction of the High Court, and we can approach the High Court, or for that matter Supreme Court, for appropriate remedy. So what we try to do today is briefly understanding the role of the court. Then we try to decide as to under what circumstances, under what situations we can approach the court so as to get a relief from the court. And thereafter, if time permits, we will try to analyze various articles of the Constitution whereby this power is entrusted upon the High Courts and the Supreme Court. Before we start, let me point out the role of the courts. Look, remember one thing, that the role of the High Courts and Supreme Courts, we will call them constitutional courts. And when I say courts, I mean only the constitutional courts. Forget about the lower courts. The role of the court is equivalent to a role of an umpire in a game of cricket. Today IPL is beginning, therefore let me take that example. The umpire does not decide who deserves to win. Umpire does not decide which team has a better merit. What umpire decides is that the game of the cricket must be played in a fair and transparent manner. It has to be as per the rules of law. If any of the sides violates any rule, any provision, any statute, then it is the duty of the umpire to set it right and make sure that the game is played in a fair manner. So court, when we say that court has a specific role to play under the Income Tax Act, the only role that the court plays is that of an umpire. Court is not playing the game. Court is only supervising the game. Game is being played between the taxpayer and the administrators, authorities. And in that game, what has to be observed is that none of the parties should violate the provisions of law. With this background, let us look at the exact rule as regards the courts and its formation under the various provisions of the statute. Look, we all know that taxes are the price that we pay for civilization, and everyone must pay their taxes diligently without evading any of the taxes that we are required to pay. Having said that, is it prohibitory so as to reduce the burden of the tax? The answer is empathetic no. Every citizen has a right to pay the minimum amount of tax. We all know that tax goes into building the nation, and tax is a revenue source so that government can function properly. And that is, as the jurists have rightly said, that is the price that we pay for civilization. And therefore, the next question is that if I am contributing less in this process of civilization, am I guilty of tax evasion? Then the answer is obviously no, because every citizen has a right to arrange their affairs in such a way so as to minimize their tax liabilities. But those efforts, those planning must be within four corners of law. If I say that, sir, I start accepting the fees in cash, and that way I am planning my affairs so as to minimize my tax liabilities, then that is not the correct way of doing it. However, if after I file my return of income, and if I feel that I have made an investment of 1.5 lakhs of rupees, and if I claim that in my return of income, or if I claim certain allowances to be exempt allowance in my hands, then that is not tax planning. That is tax planning, that is not tax evasion. So, friends, ultimately who decides that what is right and what is wrong? Is it a matter of perception, or is it a license which is given to the income tax department? Whether they decide that, sir, you are right or you are wrong, that is where the role of the court comes into play. That is where the court would decide that, sir, this is permissible, this is not permissible. In fact, last Tuesday only, again, the entire line of judgments, right from McDowell to Azadi Bachao, thereafter a large number of other judgments, wherein the view that is taken is that in case of a cross-border transaction, can an SSC arrange its affairs in such a way so as to minimize its tax liability by structuring various subsidiaries across the globe, and more specifically to those countries where there is that favorable tax treaties, whether that is permissible, and what is the significance of TRC, tax residency certificate. That matter is again started before the Supreme Court. Department is once again making an effort that if you are routing your investment through Mauritius, then you are all probability trying to take advantage of that Mauritius treaty. So again, the issue is at large. We all thought that we have buried the ghost of McDowell and House of Westminster. However, the law is yet in the process of, still in the process of evolving, and the hearing has started. Department's arguments are over. SSA's arguments again would like to continue from Tuesday onwards before the Supreme Court, and therefore very soon we'll have a verdict which will once again decide the tax landscape in the years to come. Definition of tax, we all know, it is there under the Constitution. Taxation is defined. Taxation includes the imposition of any tax or impost, whether general or local or special, and tax shall be construed accordingly. This is the definition under the Constitution, and that definition percolates down to the Income Tax Act, wherein the next definition, that is clause 29, tax on income, includes tax in the nature of an excess profit tax. Now again, this is an old definition, needs a relook, and that is the reason why government has come out with a new income tax bill. We all thought initially when the bill was available on the website that there are hardly any changes. However, once we start reading through the fine prints, and they always say that the devil lies in the details, we find that there are a large number of changes which would affect all of us, some more, some less, but then there are changes, and therefore that the new bill again is going to create a lot of problem in the days to come, because right from 61 the law was considered to be settled, and now we have the new bill trying to unsettle the settled law, and it's very human that every time there is a change, the first reaction is to oppose that change. And thereafter, once we find that change maybe is for good, then probably we need to concentrate on that. I do not know as of now whether it is a good change or a bad change, but nonetheless change is there, and we all need to spend some time on the bill and try to study it. What is the role of a constitutional court? Look, in India we have a system whereby courts, they play a dual role. The first is very easy to understand. It's an appellate role, whereby under large number of statutes, including under the Income Tax Act, there is an appeal which lies before the High Court, and thereafter there is an appeal which lies before the Supreme Court. The statute itself provides that if you lose before the tribunal, Income Tax Appellate Tribunal, then the appeal would lie before the High Court, and thereafter appeal would lie before the Supreme Court. The fundamental difference is that those appeals would only involve a substantial question of law, and the facts would not be revisited by the High Court. Therefore, that is the appellate role. And then today we are not discussing the appellate role, because we are discussing the constitutional role of the court, which is being played in a slightly different compartment. Appellate role is one part of it, and many a times it is confused with the constitutional role. Look, the line of demarcation is that insofar as the appellate role is concerned, the rights of the appellants would be decided by the statutory provisions. So if the law says that appeal is maintainable in a particular set of facts, particular set of circumstances, if it involves substantial question of law, then we have to go by that. Whereas the constitutionality or the constitutional role of the court is completely different. It flows only from the reading of the Constitution. And many a times, what you read is not what you practice. Take an example of right to privacy. Now, right to privacy, as a matter of fact, is not a right which flows from the reading of the Constitution. Nonetheless, in Puttaswamy's case, Supreme Court has decided that right to privacy is a fundamental right. If right to privacy is a fundamental right, then can Income Tax Department access my emails? Can Income Tax Department access my mobile phone? Because that falls within the boundary of privacy laws. I may be having large number of things in my mobile phone, unless they have specific information that I am hiding my undisclosed income or undisclosed assets. Can they simply, by way of procedure, enter my house one fine day at 7 o'clock in the morning and take the mobile phones of each one of us, including my phone, my wife's phone, my mother's phone, my daughter's, my son's, everybody's phone, and they try to copy everything and then they use it in whatever manner. And nowadays the very disturbing trend is they release what is incriminating to the press directly. So what I read is that so-and-so has done this thing, has done that thing, he ordered 4 bottles of liquor, and he is also consuming liquor without there being any permit. Now this is something which is in violation of right to privacy. So what kind of role a court can play in controlling this kind of a situation? Because we don't read that into the Constitution. And therefore, I'll also discuss that aspect of the matter at the right time. But I'm just only indicating that the role of a constitutional court is to maintain the sanctity in the society. And that sanctity is something which is written plus something which is unwritten, nonetheless binding on all the sides. So both these collectively decide what is constitutional and what is not constitutional. And in next few slides, we will also understand that in the context of Income Tax Act, when is it that we can invoke the extraordinary jurisdiction of the court in contending before the court that, sir, these actions are not constitutional. You kindly protect me. Either it is a violation of fundamental right, or the action is without jurisdiction, or the action is grossly barred by limitation, or a large number of such issues which one can raise before the constitutional court. Therefore, broadly, what can be challenged before the court? This is the heart of the today's discussion, because many a times we do not know that, sir, can this action be directly challenged? And by the time we come to know that this action could have been challenged before the court of law, probably much water would have flown under the bridge, and therefore we are told that, sir, no, now it's too late in the day, only remedy available to you is the appellate remedy. So what is it that can be challenged before a constitutional court? There are broadly 5 categories of challenge which one can think of where the actions of the income tax department can be challenged. Obviously, the first is virus of a statutory provision, rule, circular, notification, because all of us are aware that you can't challenge the virus before Commissioner appeals. You can't tell him that, sir, 43B clause F is in violation of the Constitution of India, or for that matter, section 115 BBE is in violation, because when the 115 BBE section was introduced, the bill said that in order to protect the government when demonetization is going to be introduced, 115 BBE is as a temporary measure introduced into the statute book so as to tax those transactions wherein unaccounted cash in high denomination notes are deposited into the bank account at a higher rate so as to prevent people from abusing that kind of activity. Now that is over. In 2016-17 itself, demonetization is over. Can thereafter one say, now before the Commissioner Appeals or Tribunal, can I say that, sir, 115 BB has lived its life, its purpose is already served. Now without there being any purpose, or the purpose which was there before the Parliament in finance bill as well as notes on clauses, one would find that that purpose is already achieved, that has served its life. Now can that section still continue, and can I challenge the virus of that section before the Commissioner Appeals or Tribunal? Because Tribunal and Commissioner Appeals are also the creature of that very statute. So once the Income Tax Act defines who is Commissioner Appeals, what is Tribunal, can those appellate authority which are drawing their power from reading of the Income Tax Act, can they question the validity of a section or a circular for that matter? The obvious answer is they can't do it. So if they can't do it, who can? It's only the Constitutional Court which can, in a given situation, question the Parliament about the power of the Parliament in enacting that particular law. So obviously, first part is you challenge the virus of a provision. You challenge the virus of a rule, notification, circular. The second part is there are large number of orders against which appeals are not provided. 119 order, 264 order, all those orders, 179 orders. We will discuss one by one that what are those orders and against which if there is no appeal, obviously one is not left without any remedy, and therefore those orders can straightway be challenged before the Constitutional Court. And mind you, when those challenges take place, there the criteria of appreciation of the controversy by the High Court are different. There High Court would not only decide the jurisdiction part of it, the procedure part of it, High Court would also decide and briefly touch the merits of those cases as well. And therefore there probably a greater leeway is available with an SSC in pleading the case before the High Court. See, any action, inaction, order, direction, notice that is issued without jurisdiction, illegal and or against the express provision of the law. That is the third category. I receive a notice under 148. I receive a notice under section 153C. I receive a notice under section 153A. I am subjected to search. I want to challenge all these actions. Where do I go? I go to the Constitutional Court, because if I can demonstrate that this notice is without jurisdiction, barred by limitation, not issued by the correct authority, or it is simply the reasons which are recorded, the satisfaction which is recorded for the purpose of issuance of this notice are simply not maintainable, not correct, I can go to the court and straightway challenge any of those actions, be it a show cause notice, be it an action, inaction, anything I can challenge before the court of law. Clause D, any action, inaction, order, direction, notice that is in breach of principles of natural justice. I ask for material, without providing me with the material, I am called upon to comment on the material. How do I comment on the material? A statement of a person is relied by the authorities in reaching to the conclusion that I have entered into some hawala transaction. However, that access to that person's statement is not given, much less an opportunity to cross-examine that person. then where do I go? How do I challenge that action? Because if I do not do anything at this stage, it will culminate into order, and then the long remedy of appellate proceedings, first appeal, second appeal, and nowadays we all know that there are huge pendency before the first appellate authority in excess of roughly around 6 lakhs appeals are pending before the first appellate authority. And our experience is that even if more often than not, they do not decide the matter. They sit tight over the matter. Once we file the written submissions, they say, all right. After 3 months, when we have once again received the notice, you have to say anything, we once again re-upload those submissions, paper book, synopsis. Once again, nothing happens. So this cycle goes on, and we all know that during the pendency of these proceedings, the demand stays. It's not that the demand is also not enforced against us, then we are happy. Let them take whatever time they want to take. Now Gujarat High Court has started taking in one of the cases, Om Vision Infra Bill, that if despite submission, despite making efforts, if the appellate authority is not disposing your appeal, then there is an automatic stay provided your appeal is pending beyond 250 subsection 5A. That is 1 year outer limit is prescribed. Section says that every commissioner appeals should try to dispose of the appeal within a period of 1 year. It's just should, it's not a must. But nonetheless, court said that if the statute say that within 1 year appeals are required to be disposed of, and if they do not do it, if they do not function their appellate work properly, then you can't penalize the SSC in enforcing the recovery against them. So in those situations, probably one can approach the court and say that, sir, my appeal is not taken up, but my recovery process, recovery pressure is still on, and protect me in the meanwhile. Court would do that. That is where the action or the action can be challenged before the court of law. And any other action or inaction in maintaining the rule of law. Now, rule of law is again an interesting facet. We will discuss that at the right time. Let us look at all these challenges in a slightly more detail, so as to understand the what is encompassed within those challenges. A virus challenge. Constitutionality of a provision can be challenged on large number of grounds. And most of the grounds, we find that there are large number of judgments. So the law more or less is settled. And one can, right from beginning, one can say that competence to tax. Now, we all know that the competence comes from Article 265. No tax can be collected by the government without the authority of law. Now, that has to be read with List 1, Entry 82, Article 346, which gives, basically the Constitution has a structure whereby there are two parallel stream of collection of tax. One is by the central government, another is by the state government, and there is a concurrent list as well. We are concerned with income tax being the central statute, therefore the central list. And in central list, there is a power to collect income tax by Entry 82. So therefore, one has to see that whatever that is sought to be collected from me is whether that is falling within the definition of income or no. Can one say that the definition of income, which again flows from 2 into bracket 24, is an inclusive definition? Because one would find, let us take an example of an asset getting destroyed in a fire. We receive insurance claim, and the insurance claim is now sought to be taxed. The SSC believes that this is not an income. It is a compensation, and therefore it cannot partake the characteristics of income. Once it fails the test of income, it does not fall into Entry 82, and therefore any tax on that compensation is in violation of constitutional provision, because it is without the authority of law as prescribed under 265, Article 265. Can I challenge that action before the court of law? Again, now the law is amended. These kind of compensations are made taxable. And good old days, Vanya Silk Mill was a judgment on those lines, wherein the court said that no, without authority of law, you can't collect any amount of tax, because tax is a burden. Tax is a levy which flows only from Constitution. And if Constitution permits collection of tax on a particular receipt, then only that receipt would become income. Every receipt would not partake the characteristics of an income unless constitutional authorizes so. Then the fundamental rights, again Article 14, Article 19, 1G, wherein all these fundamental rights are prescribed. We will discuss one by one all these rights and how these rights again can be pressed into service in a real life situation. Then apart from that, penalty and high tax rate in the nature of penalty, whether income and penalty are two different things or they can be equated. One can argue that, sir, this is nothing but penalty and therefore it is not an income. You can't collect tax on income and in place of income replace it with a penalty provision and then collect any taxes on that. That is also something which is not permissible. Retrospectivity. Can one amend the law retrospectively so as to tax a transaction which was, when the transaction was entered, not taxable? And reading down of various provisions so as to make sense out of it. If the provision is appearing in the statute book in a particular manner, does not make any sense, or even if it makes the sense, but it does not help the authorities, parliament, in achieving the object for which it is enacted, then one can read down the provisions of the law. And for that matter, we can approach High Court under Article 226, Supreme Court under Article 32, under various heads of writs. Let us go one by one. Article 14, equality. What is it that is considered by equality? Look, the law says that if two SSEs having identical facts, then both must get equal treatment in the eye of law. So equals must be treated equally under the Constitution. And unequals should not be treated equally under the Constitution. That is the law. So in case if you find that there is any violation to this, if two classes, because the courts have also recognized that it is not necessary that everyone must pay the tax equally. Unlike indirect tax levy, GST, glucose biscuit. If I go and buy glucose biscuit, maybe my income is a few crores of rupees, I pay the same amount of tax as my driver or as my peon. Because we both purchase the glucose biscuit at the same price, whatever taxes are embedded therein, we both pay the taxes at the same rate. However, income tax is always on the income. And therefore the courts have recognized, and it is an inherent feature of our Constitution, that there is a concept known as intelligible differentia. Intelligible differentia is where the parliament recognizes that we will have a different class. Within the class, we will treat you equally. However, we will tax you in a different manner. That is permissible. And that is the reason the slab rate of tax is a classic example of that intelligible differentia. That if your income is up to 12 lakhs now, that magic figure has come, then you don't pay any taxes. And if it is 13 lakhs, you pay taxes. So there, one cannot file a writ petition and say that, sir, why have I committed any crime? If my income is 13 lakhs, why I'm called upon to pay taxes, whereas my neighbor is not paying any taxes, and therefore there is an inequality. Article 14, you give me the relief. That is not permissible. So, having learned that there is an intelligible differentia, there is a class of taxpayers, can thereafter one challenge by invoking Article 14 and say that, sir, no, I still want to contend that classification is not correct. So that is where the courts come into play, and Article 14 comes into play. This was a case, I have cited one case so as to make everyone understand the concept. That was a case where 80HHC retrospectively got amended, and 80HHC, all of us are aware that it was an incentive which was given to exporters. The parliament created two classes of SSE, one up to a turnover of 10 crore, another class of SSE beyond a turnover of 10 crore, and then they said that up to 10 crore, no conditions, beyond 10 crores, you have to fulfill certain conditions, and that too retrospectively, when the deduction itself has attained the sunset clause, it has ceased to be there in the statute book. Nonetheless, law was retrospectively amended, and the court was called upon to decide that whether this classification, up to 10 crore and beyond 10 crore, can it fall under that leeway or the freedom which is given to the parliament, intelligible differentia. Court said that there is no logic for treating an SSC up to a turnover of 10 crore, beyond a turnover of 10 crore, therefore that classification is not proper. You are trying to tax two SSCs who are otherwise equal in an unequal manner, And therefore, that law is held to be unconstitutional, ultra vires, and it was struck down. So that is the concept of equality. Then there is a concept of arbitrariness and manifestly arbitrariness. What is arbitrary and manifestly arbitrary? Arbitrary is basically irrational. However, everything which is irrational is not arbitrary. And what is manifestly arbitrary is something which shocks the conscience, which makes you believe that, sir, this is something which is not at all possible. If that is so, then it is known as manifestly arbitrary. Now, these are the two facets where one can challenge under Article 14 a particular statute. This was a case, Supreme Court decided in the case of Pepsi Foods, where they were concerned with the power of the tribunal in granting stay to an SSC. My appeal is pending before the tribunal. I apply for stay. Stay will have initially life of 6 months. Beyond that, further 6 months extension powers are available with the tribunal. However, after that, the law said at that point in time when the parliament enacted the law that beyond 360 days, whatever may be the circumstances, tribunal does not have power to extend the stay. Even if the SSC is not at fault, then also power to extend the stay beyond 360 days is not available. Therefore, SSC challenged that. That, sir, what do I do if the bench is not functioning? If tribunal benches are not functioning, maybe appeal is fixed within that 360 days or for a period of 5 times. 5 times the appeal was listed. On each occasion, bench was not functioning. Therefore, where is my fault? Or every time, the income tax authority asked for time. Department took time. So what is my fault? If there is not my fault, or if the action is beyond my control, isn't that amendment arbitrary when it says that no extension beyond 360 days? Supreme Court said that yes, this is not arbitrary, this is manifestly arbitrary, because law cannot be blind to the real life situation. You can't enact a law without appreciating the correct position in law, and therefore they struck down the provision as it is, that you can't have a provision which is arbitrary in nature where without fault of SSC if the stay is not extended. Then comes the confiscatory part of it. In the garb of a taxing statute, if the action amounts to confiscation, then one can challenge the constitutionality thereof. Benami Act, again, is a specific act which says that if the property is Benami, they will confiscate it. However, income tax is not a confiscation statute. It's a statute which taxes the income. So if some provision of Income Tax Act is enacted in such a way that it amounts to taking away the entire income and thereby preventing the citizen from carrying out its business activity, can it not be challenged in the court of law that this amounts to confiscatory exercise of parliamentary power of enactment of law? Long back in 50 ITR 171, Supreme Court was concerned with surcharge profit tax, wherein the provision was such that any undistributed profit of a company would automatically become the dim dividend, and that dividend would be taxed at such a high rate that the companies were prevented from keeping any profit with themselves. They are compelled to distribute it, and that is why the challenge came into before the court, and court said that such a power is confiscatory. 115 BB is a classic example of confiscatory statute. Not only you pay the taxes at the rate of 60%, you pay the surcharge at the rate of 25% thereof, 75%, you pay all those levies leading to roughly a rate of 77%, and by the time the assessment is framed, your interest adds up to almost 23% remaining amount. So you end up paying almost 100% towards tax, and on the top of it, there is a levy of 10% penalty under 271 SSC. So effectively, even if you earn 100 rupee, by the time your assessment is framed, your tax liability might exceed 100 rupee plus. So that is a confiscatory provision, and that is how one can challenge that. Right to practice any profession. I have every right to practice my profession. Supposing an Angadiya, he says that, sir, I practice as an Angadiya. This is permissible. In a free country like India, I can practice as an Angadiya. I am moving the valuables from place A to place B for and on behalf of my customers. So if you raid my premise and if you seize the material, which is again a stock in trade in my case, because Angadia is ultimately moving goods from A place to B place. Those goods would become stock in trade in their hand. That is not owned by them. They just, as a bailee, they accept the goods, and as a transferor, they deliver the goods. So right to practice, can I challenge the action of the income tax department when they do not allow me to practice that particular profession? Court says that 19.2 read with 19.6, that these rights, the right to do business freely, right to do profession freely, they come with reasonable restrictions. And what is reasonable is something which can only be pursued by the parliament. So what is reasonable? Again, the burden is on the state to establish, but nonetheless, one can challenge the action on the ground that, sir, this is something which is not permissible in the eye of law. Let me give you a classic example. In fact, the matter is live before the Gujarat High Court. Under Section 16 of GST Act, second proviso says that whenever there is a transaction of supply of any goods, the payment has to be made within a period of 180 days. If there is no payment within a period of 180 days, whatever is the ITC that is claimed by the recipient of the goods or services, that is required to be reversed, not only reverse along with necessary interest. Now supposing I have a dealing whereby my payment is getting due beyond a period of 180 days. My terms of entering into a transaction is more than 180 days payment terms. Let's say 360 days. After 1 year I have to make the payment. So where is the question of then having to discharge the payment so as to claim the ITC? And that is nothing but infringement on my right to carry on the business freely, because then I can't carry on that business having a term of 360 days payment. Therefore, those provisions are again can be challenged. They have to be tested on the touchstone of 19(1)(g), that whether that is permissible or not permissible. Penalty, which is, I have discussed that in the guise of penalty, you can't have a taxing statute. Retrospectivity, again very interesting facet of challenge, because that is nowadays again till 2012 it was very much there. Now recently there are certain amendments which are made retrospectively in the field of GST and Income Tax Act, which are again going to affect all of us so as to overturn certain judgments of the Supreme Court. So can a retrospective amendment be challenged in the court of law by pointing out that the parliament does not have the power of retrospectivity? Again, courts have taken a view that parliament does have power of retrospectivity. However, unless that statute is stated to be specifically made applicable retrospectively, you can't have it retrospective effect of a particular amendment. And secondly, retrospectivity can always be challenged on the ground of the power of the parliament in enacting a particular law. Reading down, again, in the case of Pepsi itself, court has read down the section so as to mean, I've already given the example that stay beyond 360 days, where the court said that unless when the matter is adjourned at the instance of the SSC, this clause will not come into play. So therefore, they have read down the condition that if I get a stay and if I start taking adjournment, then now that I've got the stay, where is the question of running the matter? I don't want to run the matter. I'll enjoy the stay indefinitely. Court said that that is not permissible. But if the matter is adjourned because no fault of yours, but because of non-availability of bench or any other reason, that the statute is read down to have that effect. That is known as the doctrine of reading down a particular statute. Before we approach the court, we rush to the court for the purpose of challenging the statutory provision. One must remember that fiscal statutes have a greater latitude. Parliament has more freedom when it comes to enacting taxing statutes. And therefore, one must remember that every time there is a statute which hurts me, I can't challenge it unless I fall within the four corners of the Constitution of India. Presumption is always in favor of the constitutionality. So therefore, if I am challenging the provision, I have to go and prima facie demonstrate before the court that this provision is not constitutionally valid. It is ultra virus for ABC reasons. And of course, when there are two views which are there, unlike the normal system where view in favor of the SSC should be preferred, here is a case where if two views are possible, the view in favor of constitutionality of the provision must be upheld as against declaring the statute unconstitutional. That would take me to part B, that there are certain orders under the Income Tax Act which are not at all appealable, because there is no appeal provided. All of us are aware that appeal always flows from the statute. Appeal is not an inherent right. Appeal is a statutory right, and therefore statute must provide for appeal provision against a particular order. If there is no provision, then probably I cannot file any appeal against that, because the appeal itself is not maintainable. So we have various orders. Order under 119. 119 is a case where CBDT exercises an extraordinary power. The whole idea of 119 is basically in order to remove the genuine hardship to a taxpayer. The word genuine hardship. Genuine hardship, if that is there, CBDT has every power to remove that genuine hardship. But genuinely speaking, genuine hardship, it never influence the CBDT. They probably have a different definition of genuine hardship. And every kind of hardship is not considered as a genuine hardship by CBDT. And therefore, more often than not, you are faced with a situation where you approach CBDT that, sir, I missed out on filing my return of income. There is a huge refund which is due to me. However, my relative passed away, or I was bedridden, or I was behind the bars when the due date for return of income, filing of return of income was falling, and therefore I had a genuine reason in not filing the return in time. CBDT would say that, no, sir, this is not genuine. Therefore, your return cannot be now regularized. Unless return is regularized, I will not get the refund claim. So the remedy is we approach the court of law. Here is a situation where I said earlier that court will have a larger leeway. Court would not only decide whether the procedures are dealt with, you were given a proper show cause notice, you were given time to file the reply, your reply is taken into consideration, CBDT has passed a reasoned order. These are all procedural aspects. However, court would also go into the sufficiency of genuine hardship. That is the merits of the matter. That whether, if you are behind the bars, can it be considered as a genuine hardship for the purpose of not filing the return in time? Cannot one not import the concept of double jeopardy by arguing that, sir, on one hand, you murder someone, you are put behind the bar, and you take that as a defense in not filing the return of income in time. Therefore, one infraction of law cannot come to your rescue so as to justify another infraction of law. And these are all the issues which court would decide in a given case. But here, remember one thing, court would also go into the merits apart from the procedural aspect of it. Then 127, your file is transferred. Supposing someone is raided in Calcutta, and that Calcutta person has miraculously have your PAN details. I don't know for what reason, but he has those PAN details along with your name, number, etc. And then Calcutta officer would say that, no, sir, you come to Calcutta, we would like to assess you at Calcutta, because we don't believe the Ahmedabad range would do you justice. So come and enjoy the hospitality of Calcutta. Can we challenge that action? The answer is, again, 127, the procedural aspect is one part, and then coordinated investigation in the post-search assessments is a second part. Court would decide. Those are the issues which can be taken up before the court. Then section 132, validity of the search. Again, I will discuss one interesting judgment very soon, what is the power of court insofar as search challenge is concerned. Then large number of such orders are there, 148, 142, 2A, that is a special audit, 220, 226, clause 3, that is the attachment order when your recovery efforts are made. Then revision order 264, again revision, there is no remedy, there is no, it is almost equivalent to 119 order, and therefore the same criteria would apply. 279, that is prosecution sanction, because before you are prosecuted. 179, that is liability of a private director. These are all the orders where one can approach the court because there is no alternate efficacious remedy which is available. Then comes the third part, the lack of jurisdiction. What is it if an action is without jurisdiction? Jurisdiction is a very, very wide term, and jurisdiction has many facets. Jurisdiction is basically the authority, the statutory authority of the implementing officer in taking a particular action. Now that is jurisdiction. It's a very wide term. When we say jurisdiction, it encompasses large number of other authorities flowing from the exercise of the jurisdiction. The first is authority of law, if the action is as per law or it is without an authority of law. There are actions which one can say that, sir, this law does not authorize you to take such an action. How can you take such an action? Supposing a search is carried out at somebody's premise. During the search, it is found out that that person has in habit of having huge transaction with a third party. In order to protect the interest of the revenue, the moment this information comes in possession of the officer, he straightway attaches the bank account of that third party. That, sir, I find huge transaction between the two accounts, and therefore, in order to ensure that money does not run away from that third party's bank account, I am putting an attachment so as to protect the interest of the revenue. At heart, I have the interest of the nation in mind, and this action is therefore justified because I believe that this is how I can protect the interest of the revenue. Now, this is an action which is without an authority of law. Law does not sanction such an attachment on a third party's bank account when the search is at a third party. There is a procedure prescribed. In the process, if more time is taken, that is what is contemplated by the parliament. And therefore, that is an action which is without authority of law. Territorial jurisdiction. Supposing I used to file my return of income in Pune. Thereafter, I got transferred to Ahmedabad. I moved an application. I intimated the authorities that, sir, I have moved to Ahmedabad. After a few years, suddenly, my old assessment year is reopened by Pune authority on the ground that when at that time you were here and you filed the return of income, therefore I have the file with me and therefore I have the jurisdiction. Is it permissible? You can straightway challenge it before the court of law, pointing out that, sir, action can be taken only by the assessing officer. And by definition, assessing officer is someone within whose geographical jurisdiction I am sitting. And therefore, Ahmedabad authority has the jurisdiction and Pune does not have it. Limitation is if an action can be challenged or taken within a period of particular time limit, one cannot go beyond that time limit and say that, sir, I am trying to justify this action, because limitation is prescribed by the parliament in its own wisdom so as to bring finality to any proceeding. Because all of us are aware that under income tax what we want is finality. That's our case, close keys. I don't want that sword hanging on me for all times to come. And therefore, limitation is a very, very important section. And if an action is beyond the limitation period, it is without jurisdiction. And action can only be taken by the assessing officer. And that is why the term assessing officer is defined under the Act. Therefore, any officer cannot say that I am the assessing officer, I want to take an action against you. Because assessing officer is a term which is not interchangeable. It's not income tax authority. It is the assessing officer. Then comes the next question, that if the notice is without jurisdiction, can one challenge the notice? In a challenge of a notice, the biggest hurdle is at what stage one can challenge the notice. Because courts have taken a view that merely because a show cause is issued to you, merely because a notice is issued to you, you can't rush to the court, because then that action is premature. You see what is what is there in the mind of the assessing officer, why you are coming here. If I wait enough, I file response saying that, sir, you do not have authority, this, that. I file the response. He passes the order. Then court would say that now that order is passed, there is an appellate remedy which is provided. You go and file the appeal. Why you are coming here? So at what stage can I challenge the show cause notice? Probably the appropriate stage is once I receive a show cause notice. Take an example of 148 or 153C for that matter. When show cause is issued, one is expected to file the response. And in that first response, one has to ensure to question the jurisdiction of the authority on various grounds. Whatever may be those grounds, one has to question the jurisdiction of the authority in issuing this show cause notice, be it lack of jurisdiction on territorial ground or on the ground of limitation or on the ground of the reasons not justified in a particular case, or assumption of jurisdiction on incorrect jurisdictional facts that you have entered into a transaction with a Hawala operator. I said that, sir, I have not entered into transaction with that Hawala operator. Okay, that we will discuss during the course of the assessment proceedings. That is not the, this is not the stage. An assessing officer will close it. Now that is assumption of jurisdiction on incorrect facts, and therefore one can challenge that action provided one has already brought this out before the authority. So moment you receive the notice, file a response. Under 148, now the procedure is defined. However, 153C or 179 or for that matter even 263, that procedure is not there. Therefore, what one has to do is, one has to simply go and file the response challenging the jurisdiction on various grounds. And that is the stage one has to immediately approach the court. That, sir, I have received the notice. Notice is without jurisdiction. I have already intimated the authority. Authority is not in a mood to drop the proceedings. Therefore, protect me in the meanwhile. That is the correct stage, and one can challenge the notice. The 148 procedure again is prescribed, so one can go to the statute, find out whether in a given case the notice can be challenged on the ground of limitation, escape income, whether that is there, not there, escapement is there, not there, information, whether it is falling within the four corners of definition of information, whether it was originally examined, change of opinion is there, and validity of the notice per se, including challenge to the assumption of jurisdiction on the ground of incorrect underlying facts. If those facts are not correct, one has to point out that the facts are not correct. If the search action is without jurisdiction, can one challenge a search action? Because many a times we read, and nowadays even the proposed 2025 income tax bill, or the proposed act, I would say, bill is not proposed, bill is already in existence. There they say that once a search takes place, AO will have every right to look into all your affairs, including your demat accounts, which is virtual, your digital asset accounts, your email accounts, everything is at large before the assessing authority, and therefore you have to cooperate, and that is a part of an offshoot of a search. Can search be challenged in a given circumstances? Because the experience is, let me tell you very candidly, that experience is, whenever we try to challenge the search, Section 132 says that the commissioner must have reason to believe that SSE is doing something so as to hide his real income. And that income could be represented in the form of money, bullion, jewelry or other valuable articles. And that is hidden at some place in his residence or some other business places. And therefore we have reason to believe, and all of us are aware that reason to believe is again a subjective satisfaction, where one can have some grounds and one would reach to a conclusion that I had reason to believe. All that is required to be seen is whether that action is bona fide or not. That is all that court would look into. They would not go into the sufficiency of the reasons, that whether one person has said that, sir, I paid own money to this builder, whether that is a sufficient evidence to rate that builder or no. Court would not go into that. Court would say that yes, there is some material available and therefore there can be a reason to believe. We raise our hands. We will not question the authorities insofar as validity of search is concerned. Recently, in fact, an advocate was also raided, part of a search. Gujarat High Court had an occasion. Gujarat High Court ultimately held that if there are grounds for searching that advocate, and if those grounds are available in the file, then we will not show any indulgence and we will not help the SSE. This was a case where, again, Supreme Court has admitted the SLP, issued the notice, and therefore issue is at large before the Supreme Court. But nonetheless, here is a case where they searched the premises, switched off CCTV, gathered everyone, all the family members, took away their phones, copied the phones, prevented the daughter from going to the college, prevented the ailing parents from going to the hospital, and some high-handedness was shown by the authorities, and rightly so every time, because all SSEs are not alike. Many a times income tax authority also find that in the guise of going to college, that person would go someplace else and delete all the evidences which are there in the cloud. Their argument is, we close the CCTV footage because we believe that someone is monitoring 24/7, and if some signs are made on the CCTV, that person will erase all the cloud data. Therefore, we are justified in all our action. And in that context, the action was challenged before the court of law. And many a times we do not challenge detection for the reason that assuming that search is held in my favor, that's the decision of the court is that search was completely illegal. Then also the law says under the Evidence Act, even if the documents, evidences, material are gathered in an illegal manner, they can still be used for the purpose of framing the assessment. So even if I get the search knocked out, that this is an illegal search, if a diary is found during the course of the search incorporating the notings as regards my undisclosed income, then that diary can always be used for the purpose of assessment, irrespective of the way in which it is taken possession of. Therefore, people would be afraid. Now there is a welcome, I would say, deviation from that school of thought. Madras High Court has very beautifully written the judgment, and they said that we go by what is fundamental right. And one of the fundamental right is right to privacy. And they say that the right to privacy is very important. We find that this search is nothing but a collection of illegal efforts. If these are all illegal, because you can't have closed the CCTV footage, if you are acting legally, then what is the harm in running the CCTV? If there is no question of, if search warrant is against me, the question of not allowing my daughter to go to the college or my son to attend his work is something which is not permissible. Only I am against me. If there is a warrant, you make me sit. However, you can't affect the other family member. Court said that now we have a judgment of the constitutional bench of the Supreme Court in the case of Puttuswamy. What does Puttuswamy say? Puttuswamy says that there is a right to privacy. Right to privacy, probably first three bullets are not material because we all fulfill those bullets. Last bullet is very important, and that is what has weighed with the court. That the right to privacy in a given case can be violated. However, that violation must be proportionate to the results, and therefore the doctrine of proportionality is pressed into service. That supposing someone has entered your chamber without knocking, doctrine of proportionality will say that you ask that person to leave your chamber. But it does not mean that you stand up from your seat and start beating that person black and blue. That is not proportionality. So, doctrine of proportionality is something where the outcome must be proportionate to the violation of right to privacy. Now, that is what court has said, that this action of not switching off the CCTV and large number of all those actions are in violation of the right to privacy. They are not proportionate to the object which was sought to be achieved, namely unearthing the undisclosed income. And therefore, these searches are, mind the words, unconstitutional. They said not illegal, these searches are unconstitutional. Because these searches are unconstitutional, therefore not a single material can be used, and they have deviated from the judgment of Puranmal's case. Yes, Puranmal's 93 ITR 505, which was an old case holding the field that even if illegal search, material can still be used. Now there is a welcome deviation, and that deviation is that forget about illegal searches, unconstitutional searches. Court can always say that this is unconstitutional and therefore nothing can be used against the SSC insofar as this search is concerned. So you can challenge the action of search also while invoking the constitutional court's extraordinary jurisdiction. That would take me to the part D of my presentation, that can I challenge the action of violation of principles of natural justice before the court? And in that process, we will also see that to what extent the alternate remedy would come in your way. What is principle of natural justice is, we all are aware that principles of natural justice is where one has to be given a proper opportunity to represent one's case in substance. And therefore, if material has to be shared, opportunity has to be given, show cause notices are required to be issued, I must be given proper time to respond. I cannot be given 24 hours time to respond against a 16-page show cause notice. All my correspondences must be logically processed, incorporated, and to be dealt with in the final order. These are all parts of the natural justice process. And therefore, any order which is in violation of this process of natural justice, because we are all are aware that now it is beyond doubt that assessment is a Rajiv Bansal has decided that the assessment, I'm sorry, Rajiv Bansal citation is there, 469 ITR 46. Rajiv Bansal decided that assessment is a quasi-judicial process. If it is a quasi-judicial process, then obviously principles of natural justice are required to be observed, because quasi-judicial process is you are not being prosecuted. Your matter is being decided by a judicial officer. Once that judicial officer is, though he has is a combination of prosecutor come judge come judicial officer, nonetheless he can't give it a go by. He can't give the principles of natural justice a go by on the ground that I am framing the assessment and therefore I am a prosecutor. Court has said this, and therefore everything which is broadly flowing from the principles of natural justice is required to be followed by him. So what are those instances? Show cause notice issued before the compliance date, assessment order is framed. Show cause notice issued, adjournment is asked for. Without dealing with that adjournment application, he straightway issues the order. Show cause issued, adjournment asked for, denied, and then assessment order is framed. No show cause notice, draft order is issued, and straightway assessment is received, assessment order is received. My reply is not considered. If considered not in a proper manner, my reply has been sought in a very, very short time, few hours or 1 or 2 days time. I asked for video conferencing. Video conferencing is not granted. Or video conferencing is granted, but on that day, because of system failure, I could not effectively avail of the facility. So on and so forth. Again, it will all depend on the facts of each case. Supposing you have asked for adjournment on 16 occasions, and on the 17th occasion, he says that, no, sir, I don't want to give you time, then that is not violation of principles of natural justice, because the principle of natural justice is a two-way street. And there, the doctrine of equality, the doctrine of equity also comes into play, that those who are seeking equity relief, they must also have the equity in their favor. So if I do illegal acts, I keep on asking for time, and when assessing officer denies on one occasion, I can't rush to the court, because my conduct is also going to be scrutinized by the court. But these are all the instances where one can approach the court and one can say that, sir, this is the order, again, which is, if it goes into appeal, even if the appeal right is available to me, I'll be called upon to face a huge litigation, which could have been avoided had he given me proper opportunity before himself only. And therefore, from saving myself to this gamut of entire appellate proceedings, please direct the authority to frame the assessment order as per the principles of natural justice. And therefore, the fundamental question is that if at all appellate remedy is available, an alternate remedy is available, why should court show an indulgence? Appellate remedy, as courts have pointed out, in fact recently in the context of the judgment of under the GST Act, wherein the provisional attachment under section 83 took place and the SSC approached the court, in that context court laid down the criteria that fundamental rights are violated. I have highlighted those criteria, that principles of natural justice are not followed, the action is wholly without jurisdiction, and virus of a particular section is challenged. Only under these four circumstances, the courts are entitled to entertain a writ petition, even if there is an alternate remedy available. The courts are of the view that the criteria is alternate efficacious remedy, and therefore mere existence of a remedy is not sufficient. It must be an efficacious remedy. So supposing I file a detailed reply. Assessing officer says that you file the reply by 27th of March. At 11 o'clock on 27th March, I upload a detailed reply. On 29th of March, order is passed, and officer writes that I do not find any reply of the SSC, and therefore I confirm the show cause notice as it is. When we approach the court of law, the assessing officer defense is, sir, I did not see it on the portal, and therefore there is no question of my taking into consideration the reply. Now that they have filed the reply, commissioner will always take that into consideration, including commissioner has a power of entertaining additional evidences. In such a circumstances, court would say that that alternate remedy, though available, is not efficacious. Because efficacious remedy is a remedy which is not an eye wash, which is not a remedy only on paper. It has to be effective remedy. An effective remedy is that this demand itself is completely without jurisdiction. The assessment order is without jurisdiction because it is in gross violations of principles of natural justice. My reply is not at all taken into consideration. However, take a situation where I file a 60-page reply. Assessing officer says that reply is considered, however, I am not agreeable to that, and therefore assessment order is framed. Then can I go to the court and say that, sir, he has not discussed my reply? Now court would say that, sir, if you file 60-page reply, then assessing officer is justifying saying that I have gone through your reply. But what is the material which is available with you to demonstrate that he has not gone through and not applied his mind? So therefore, it's a fluid situation. There is no straitjacket formula that if he does do this, then writ. If he doesn't do any of this, then no writ. No, that is not how the system works. However, the principles of natural justice, again, it's a two-way traffic, and if one can demonstrate that the authorities have acted in violation of that, writ is certainly maintainable. I have already said that it's a equitable relief and therefore the SSCs must go there with clean hands. I have covered that if you ask for time on a multiple occasion and on one occasion if it is denied, then that is not violation of principles of natural justice. We all the time we say that equity and taxation, they do not go together. However, Supreme Court way back in 1985 said that every effort must be made to make them meet. Because ultimately, the process of collection of tax is done by humans. Now, mostly by machines. But nonetheless, it is done by humans. And if we do not put equitable aspect, equity into consideration, then probably we will end up with a situation where they always remain a stranger. And in order to meet them, court has said that every effort must be made so as to bring them on some common ground and try to do justice rather than merely collection of tax. The last part, the rule of law, where it is violated. So orders are against the settled position of law. Supposing an assessment order is passed today, taking a view which is completely contrary to the Gujarat High Court judgment. Gujarat High Court has recently held that even if you place money in another cooperative society, ATP 2D is available to you and ATP 4 would not affect your right to claim ATP 2D. Assessment order is framed now. An assessing officer denies ATP 2D. Even if you cite Gujarat High Court judgment, they said, sir, we are faceless. We do not have any jurisdiction. We are not controlled by any geographical boundaries. And therefore, we will do what is required to be done as per law. Because we have not accepted that judgment. That judgment is at large before the Supreme Court. We have preferred an appeal against that. SLP is pending. Therefore, we do not follow the jurisdictional High Court judgment. Can it be said that this order is against the rule of law? The answer is obviously in the state of Gujarat, because Article 226 subclause 2 says that part cause of action અહીંયા જ બંધ થાય છે કે બેમાં બંધ થઈ જાય છે? આમાં જ બંધ થાય છે? આ ચાલુ જ રહેશે ને? ઓકે. Part cause of action has arisen in Gujarat because SS is obviously in Gujarat. Therefore, writ is maintainable, and the law which is declared by the jurisdictional High Court, we all are aware that at least in the state of Gujarat, nobody can take a contrary view. In fact, if a contrary view is taken, that is amounting to contempt of court. And therefore, that order is against the settled position of law. Then the transfer of cases, that is again against the rule of law. Supposing 127 says that from Ahmedabad to Calcutta, if opportunity of hearing is not given to you, then probably one can argue that that is without the rule of law, in violation of rule of law. Refund. Many a times we find that there is a cat and mouse fight between CPC and JAO. JAO would say that, sir, I have already sanctioned your refund. Now go and ask CPC. CPC says that matter is transferred to JAO to pass appropriate order. Where would one go? Because ultimately refund is not coming to my account. So the action is without the authority of law. You can always approach the court. Stay in a legitimate case demanding even 20% is harsh on the SSC. And therefore, one can say that, sir, these circulars are not sacrosanct. You have to make an exception. Take the prima facie case into consideration and decide my stay application. If it is rejected, I can always go to the Constitutional Court. My objections are not disposed of, and straightway notice under 148 is issued without passing 148 order. Again, it is an action which is challengeable on the ground of violation of rule of law. And every action, again, is also counterbalanced by inaction. So if you find that authorities are not taking any action on any of these issues, then even that inaction also can be challenged, and we can compel the authority in taking the action. Article 141, the law declared by the Supreme Court is binding, and Article 142, this is the last 2-3 minutes, and then we can start question answers, because I was supposed to start at 11:15, it's 11:19. Article 142 has recently come into highlight. Ashish Agrawal, Supreme Court said that in order to do larger justice, we invoke Article 142, and that is a part of the Constitutional Court's functioning. Can Article 142 be pressed into service like this? Thereafter, Supreme Court in the case of Allahabad High Court Bar Association had an occasion to deal with this. It was a constitutional bench, this Allahabad High Court 2024 6 SCC 267, wherein the court said that, paragraph 24 to 27, court said that Article 142 cannot be pressed into service like this. If it affects the rights of a citizen, then all those affected parties' rights must be taken into consideration, and it cannot be decided without hearing those parties. Because my matter cannot be decided by Supreme Court without even hearing me. And that is precisely what has happened. In Ashish Agrawal's case, court noted that there are 90,000 matters which are pending at some level or another. In many of the cases, even assessment orders were framed based on the old notice. Court has said that this has pan-India implication. Article 142, in order to do larger justice, we set aside all these notices and re-initiate the proceedings under the new law. Now, the later bench of the Supreme Court has said that that is not what is contemplated under Article 142. And probably in appropriate case, at some day, Supreme Court would decide whether this action, etc. of Ashish Agrawal read with this later judgment was in order or no. But Article 142 is nowadays used by the department as a weapon so as to set right all things which are pending. Take an example of JAO versus FAO. The controversy is that who can issue the notice of reopening, whether it is the jurisdictional assessing officer after 29th March 2022, when the scheme is notified, and as per that notified scheme, only the NFSC has the jurisdiction to issue the notice. So all those reopening notices issued after 29th March 22, whether they are with jurisdiction or they are without jurisdiction. Court is seized of the matter. Probably someday we may see even Article 142 once again coming into play and dancing in front of our eyes. We will wait for that day. With this, friends, my part is over. Now I open the house for question answers. Thank you. Thank you.
Ladies and gentlemen, please put forth your questions. Yes. Yes, please. You don't have a mic? 1 minute.
Good morning, sir.
Morning.
Before asking a question, I just want to confirm one thing. Is my understanding is correct that all unconstitutional searches are illegal search, but not all illegal searches are unconstitutional?
Perfect.
So, sir, I want to ask a question is that when one can challenge the provisions related to search on the touchstone of constitutional principles, how can a search itself can be challenged on the test of constitutionality? And if as an advocate, I wish to argue any particular search as illegal or unconstitutional, what will be the key difference in my arguments before the Honorable Court?
Look, facts would decide. Eventually, if you look at SRJ's judgment of Madras High Court, the facts would decide whether a search is illegal, unconstitutional, or it is a search which is within four corners of law. There is a detailed SOP declared by the Income Tax Department that is available on their website also. You look at the SOPs, you look at the action which is taken during the course of the search. Now again, the problem is how have you documented the actions? Because you say that there was this classic case where during the search party compelled the housewife to make bhajiyas for them. Now, there is no proof that there is such a high-handedness in their action. So how do you prove that? And more often than not, the problem is with panchas. Look, the whole idea of search is that you call the panch. Panch etle someone who is an independent person who acts as a panch and who witnesses the whole search, and they certify at the end of the search that the whole search has taken place within four corners of law. Now, more often than not, you find that they come with their own panchas. So ultimately, how do you decide or how do you prove that this is what has happened? And then if you have documented all these things which are again difficult to prove in the court of law, but in case if you have any proof, like if you have the proof that your daughter has not attended the college because her attendance would be marked as absent, if you have proof that a lawyer is not allowed to attend the court because on that day his matters would be adjourned because he is not available, if you can prove that CCTV footage was not available during that period, if you can prove that there was an unauthorized access, the mirroring of all the family members' mobile phones, these are all the things, if you can prove it, then probably you can say that this was a search which is unconstitutional, not only illegal but unconstitutional. In fact, you would find that there is a judgment of Paresh Chauhan, wherein Gujarat High Court has laid down in the context of GST the detailed guidelines as to what such parties should do and what they should not do. Based on that, if you can demonstrate, if you can call out certain facts, then highlight those facts and argue the matter that, sir, these are the actions which are unconstitutional in light of Puttu Swami's judgment, and that is how you can plead your case before the court.
Hello. Sir, can any kind of authority taking the any kind of sudden decision regarding like rebate 87A, XML change कर दिया, then after थोड़े दिन के बाद फिर शुरू कर दिया, फिर information दी. So now this kind of act doing by the authority, can we file any kind of appeal? File तो हुई है, but किस तरीके से step होगा?
Appeal is always maintainable. You can always file appeal. In fact, there are appellate authorities judgments also available where they have taken a view in favor. Constitutionality thereof was already challenged before Bombay High Court.
Okay.
Bombay High Court has given a detailed guidelines. So again, look, the fundamental question is that does it make commercial sense?
Yeah.
For 7,500 rupees, can you afford to go to a court of law unless you, of course, you have an issue with the way in which department is functioning, but many a times we have to also keep in mind the ultimate benefit to the SSC. So appeal remedy is always available, 87A. Bombay High Court judgment is also there now.
Yes, but they can not consider this judgment.
Right. So if they do not consider, you have appellate remedy available with you. In a given case, you can always approach the court that, sir, they are bound by this, because the law is 113 ITR Godavari Devi Saraf.
Yes.
The law is that if there is a solitary judgment in the field, then it binds all the authorities. Now, all the authorities means only the appellate authority, not the original authority. So therefore, if CIT appeal rejects your appeal, then you can always file a writ. But again, as I'm saying repeatedly,
We need the association of the...
Absolutely.
Yeah.
Now that PIL to what extent maintainable? Again, Gujarat High Court said that in such a case PIL is not maintainable. So you will have to find your own poison and go according to that.
Thank you. Thank you.
We take up the last question.
Sir, yesterday we had our guest J.M. Patel sir, and while discussion, the things came out that there are DLSA, District Legal Service Authorities, and Taluka level legal service authorities. The problem arises is government is bound to give lawyer to the criminal offences,
Right.
not to the tax or anything.
Right.
And there are certain, like just now he has said that it is not maintainable because of the amount. Can there be a mechanism which can be established where the taxation matters also will be covered under the DLSA?
You can make a representation because, look, the taxation arises when you earn income. And therefore, the presumption is that you have income. Whereas a criminal person, the crime can be committed by anyone, and more often than not by someone who does not have any means to defend his or herself. Whereas in tax laws, the presumption is, because in good old days, in fact, we also started, when I was active in IT80 bar, in fact, I am still also today also very active in IT80 bar, we also started a legal aid clinic. We informed the High Court legal cell also that in case if you find that any person, any SSC is deserving and does not get any proper legal representation, we would be ready and willing to help without on a pro bono basis. But then our experience is that such an action is not workable. It's not something that we do not want to do. We are always open, and in fact, all my colleagues, all those persons who are at the helms of tax bar, they are all willing and welcoming all pro bono SSCs, but we do not find them very often. And therefore, the presumption is this only. And many a times, this small SSC's cause of action is there. Associations can take up those cause of actions and try to find a solution at a larger level, maybe before the parliament by talking to the local MPs, etc., rather than through the court of law route. Because that is something which is nowadays my personal feeling, that litigation has become prohibitively expensive. It has become a luxury which can only be enjoyed by few taxpayers and not by all of them. And therefore, I always advise the small taxpayers that do not enter into any fight with the department. Rather, pay the amount and get rid of them. Rather than, carrying the matter before the higher authorities in uncertain world, it is always better to pay the taxes and buy peace of mind and enjoy your rest of your life, rather than, running with those files to and from the lawyer's office. Friends, with this, I believe it's end of the session.
Let us all give a standing ovation and a heartfelt big round of applause for Sir.
Thank you very much.
Sir, a structured overview provided by you at the outset effectively set the stage for focused engagement, ensuring a clear understanding for a layman like me, for the beginners and even the experts in the field. Your ability to deliver complex information with clarity and precision significantly enhanced the audience's comprehension. We are grateful for you to throw light on the evolvement of the cross-border transactions, sir. And last but not the least, your acknowledgement of both the organization's dedication and precision in bringing the tax conclave to fruition is highly valued and greatly appreciated. Thank you so very much for the honor, sir.
Thank you very much. Jai Hind.
At this instance, we would like to felicitate the committee members at the hands of Sir Advocate Tushar Hemani. Sir, may I please request you to felicitate, beginning with Advocate Hiren Vakil, sir. Let us put our hands together, ladies and gentlemen. Followed by CA Maulik Patel, sir. Advocate Umesh Majmudar, sir. Advocate Jignesh Bhagat, sir. CA Raghav Thakkar, sir. CA Parth Doshi, sir. CA Suvrit Shah, sir. And Advocate Anil Timbadia, sir. So thank you so much for the felicitation. Here we come to the end of the 5th technical session, and now I invite the dignitaries on the dais to please come forward for a group photo session.